Well, legal analyst Mpumelelo Zikalala joins us for more on both the Senzo Meyiwa Murder trial and the Oscar Pistorius parole application. It's always a pleasure to see you, Mr. Zikalala. Thanks very much for joining us here on SABC News, sir.
Good evening to you and also good evening to your viewers.
All right, I want to start, of course, with a number of issues relating to the Senzo Meyiwa trial before we move on to Oscar Pistorius. I want to start by talking about this importance of the evidence by the DNA expert. I mean, obviously, we'd be expecting that, you know, some sort of DNA would be found of those that were within the house. Obviously, we're talking about Kelly Khurumado's mother, Zandile Khumalo as well. We would expect, given that they are occupants of the house. So was it important to note that, you know, the DNA was found on objects that they would likely have been touching within the house anyway?
It's important in a number of aspects. The first one is to say, yes, there were individuals that were in the house, but most importantly, let's look at where they are found. Now, if your DNA is going to be found in an alcohol swab, then the insinuation would be, were you drinking on the date? Do you remember exactly what the sequence of events was? Can you be able to recall accurately as to what exactly happened? If they are going to be certain doubt which is cast upon the manner in which you've been handling yourself, then certainly it's going to have an impact in the evidence that which you are going to provide. Then on the all other accused, for example, accused 1, 3, 1, 4, and 5, if I'm not mistaken, that means that they are then excluded from that particular crime scene. You need to find another way of bringing them back in to the crime scene, and the chance of improving that they are guilty beyond reasonable doubt certainly diminished by this particular occurrence. Of course, there's still another opportunity through the doctrine of common purpose, but for now, I would say that it is a huge blow to the state's case in terms of saying these are the individuals that were in the house, and these are the individuals orchestrated the deadly blow to Senzo Meyiwa.
How does the state recover from this? I mean, if I'm just thinking now, might they then have to look back at what had been perceived as incompetence of the police that were handling the scene, for example? Because as you say, this is problematic for the state.
There's very little chance of recovery unless if you're going to come back and say the ones in which the DNA has not been found in that particular place with the actual, or they were part of the masterminds, or they carefully thought, or they're involved in the planning of the whole thing. Hence, I stated earlier that the doctrine of common purpose will then have to kick in. But if you can't do that, then definitely this is going to be a huge blow to the state's case. What is also a matter of concern to what has been raised by the defense previously. Now, this evidence is coming after certain individuals have gone in and testified. For example, Zandile Khumalo and all the other individuals that were there, especially the occupants that were in the house. And this is the type of information that should have been tested on them to say, if you are saying that the person was wearing a hat, DNA has been collected, and there's no DNA which is linking this particular individual. Are you telling the truth now, or are you misleading the court? Those are the type of questions that should be placed on the particular witnesses. And now when they are gone, it's either you recall them again, which is going to cause further delays, which is not something in which I think even the state would want to happen at this stage.
Yeah, I see that the state is also quite keen to bring up the issue of cell phone evidence, and that might maybe be where they save themselves, you know, as you sort of insinuate there. I want to talk about this important issue of cell phone evidence, and let's break Section 205 of the Criminal Procedure Act, you know, for the sake of our viewers. What does it say necessarily in terms of in relation to cell phone evidence, and why was the defense so eager to kind of, you know, invoke that, to say, listen, we never used Section 205, we were not presented with this. Why was it important for them? Is it a case of just buying time? I mean, at the end of the day, it will come back, won't it?
Yeah, it will. Well, we have to look at the sort of admissions that are there. If you've admitted certain things at the start of the case, then it's difficult for you to go back on it.
Yeah.
But when it comes to cell phone evidence, this is the shortfall of the type of evidence. It does prove that there's communication between the two parties, but does not prove the content of the conversation that is there. So it may prove that you and I have been calling each other, but in terms of what you've been discussing, something is not, you can't extract that unless the phone has been carefully tapped and entrapment processes have started. So I think for the defense, they're simply going to highlight instead, yes, there may have been communication that has taken place, but it does not prove that the communication was in line or with regards to the matter of Senzo Meyiwa, or even disputes that it even belonged to them in the first place. Because you can even have a cell phone which complies with all the RICA legislation, however, is not used by the person who's supposed to use it at the time. So which is why the defense is then saying, we are not going to simply admit this particular evidence. Call the expert to come in and explain to this court and show the shortfalls in which we want to lament it based on record. Basically of saying, yes, there may have been communication, but we're not sure as to what the communication was about.
So it seems that you agree that the court was correct, or rather made the right decision by holding off, when it comes to cell phone evidence pending readiness. And I suppose that then also ultimately helps both sides in that, the defense also has time to figure out, how problematic or lethal this might be, to their own case.
Definitely, and it gives time for them to go and prepare and go and consult. Once you've received new information, you go back to a client and you say, this is the information that I have. What is your response pertaining to this? But I would like to blame the state for the delays in this instance.
Yeah.
The information has been within the hands of the state for a very long time. Provide the evidence in which is going to follow. Even if you say evidence is cropped up during cross-examination of another witness, there are two counsels that are sitting there. And each time the matter ends, you can then have the opportunity of going back and say, this is how we're going to develop our case. Do not call a witness in which evidence has not been passed over to the other party. It's bad in terms of preparation. It's bad horsemanship in terms of going to court and providing information in that manner.
Which is what was kind of surprising to me, Mr. Zikalala, that, Advocate Boloi for the state said, look, this doesn't really matter. Section 205 isn't necessary and won't apply to the representative, I believe, who's coming from one of the cell phone operators, I believe, Vodacom. He said it doesn't matter, but it actually does, doesn't it?
It does. Whenever an expert comes in, they need to be handled in the manner in which experts are handled when it comes to court. So give me a brief of what the expert is going to talk about. It gives me enough time to go and prepare to say, do I need my own expert to come and rebut whatever that they're going to say? Or do I need someone who's going to have a much more expert knowledge than the one that I have in dealing with this information? Don't come to court with an element of surprise. That only happens in movies. When it comes to the court of law in what we do on a daily basis, you give adequate notice, give ample time for the other side to go and be able to prepare, so that when I dispute or admit whatever that you are coming with, I do so having full instruction and consulted with it with my client on a much more thorough and comprehensive manner.
Yeah, I think this is the right time to move on to the Oscar Pistorius case. I think you've helped us enough with the Senzo Meyiwa case. Let's talk about Oscar Pistorius. Of course, we've now heard that Oscar Pistorius was indeed eligible for parole in March already. But eligibility doesn't necessarily mean that one is entitled, right?
No, not at all. It simply means that the door has been opened for the assessment process to begin. There would have been reports which come in on a regular basis to the parole board to say this is one of the candidates. So his file has been built up, and the only thing which is required, in which was the point of contention by the looks of things, was the amount of period in which one is eligible for parole. And one could forgive maybe the correctional services for making the mistakes if you're going to get a directive from the court, the SCA, not just any court, saying that this is how we're determining the amount of eligibility or the years or the duration of incarceration. You are certainly going to believe that. We have no reason to dispute what the SCA is stating. So it was only the court that could have come to the aid in terms of, and then come back and say, well, actually, this is the correct way of calculating the issue of parole. This is the manner in which this particular process is going to be dealt with.
Let's talk about that calculation. I think we were always taught it's 2/3, but that's not necessarily, how exactly is that calculated? We know that Pistorius is currently serving a 13-year and 5-month prison sentence for that 2013 murder. So how is that actually calculated?
In fact, it's 1/3 or 1/3 or 1/6 of the sentence in which you've been given. So if you've been given 13 years, you then say what is the 1/3 of that particular period, and then the assessment period will actually begin. And the question would be, have you attended enough courses inside jail? Have you attended the victim and offender dialogue, and what's the perception between the two? Are you a person that is eligible for parole? And is the process, or have you changed the way in which you came in prison? Have you changed, and are you eligible or are to be a changed person at all? I do have a problem with that, though. Because it tends to be a tick box exercise and not a question of assessing whether the person is changed or not.
Okay.
So you then come back and go to court and fight about the terms in which I've been spent in prison. But when it comes to where the victims have been considered, where they say no and it's the end of the case, it doesn't matter to you anymore.
Yeah.
And what adds to this is the recent that's been issued by the court pertaining to Mr. Pistorius, who basically indirectly the court was telling us, when it comes to parole, it is purely a checkbox exercise. If you tick all the requirements, you've complied with everything, you are eligible for parole, you ought to be released, which is something at the end of the day should not be considered. You cannot live out the voice of the victims.
Yes.
And if it was according to me, the victims are saying no, then it means you shouldn't be released at all.
And it's even more complex, isn't it, at this time? I mean, in this particular case, River Steenkamp's father, who'd been, very vocal about his hurt and pain about, his daughter's murder, has now also, in fact, passed away. So he passed away actually not having forgiven, Oscar Pistorius. I suppose, the way that you explain it now, that won't be there won't be any relevance to that, will there?
Not really. Checking to what the court has stated earlier, yes, there may be a consideration which is done when it comes to the victim, but listening to what the court was actually saying, it was purely becoming a checkbox exercise. And you then come back and say, maybe it's high time in which the Correctional Services Act is amended to accommodate when it comes to victims, or do the honorable thing when it comes to court processing and court prison terms and say, this is the amount of the term in which you are going to spend in jail, including or making cognizance of the time in which you can be released on parole. So I, sitting in court as the victim, the relative of the victim, or the person has been wronged by someone, have got a careful understanding of this person is going to spend an X amount of time in jail, and do not expect miracles at the end, because now what we are doing, we are selling dreams to those offenders. We're saying that the person is going to spend their whole life in jail, and at the end of the day, it doesn't happen. This is not an element of justice.
All right, Mr. Zikalala, we always appreciate your time here on SABC News, sir.